Gentlemen here in the name of Laing and Underhill Children's NHS Foundation Trust.
Yes, Mr.
My lords, my ladies, may it please...
You don't need to wear your mask.
Ah, of course, thank you so much. I appear on behalf of the appellant, Ms Byrne, with my learned friend Mr Jones, and Mr Gorton, Queen's Counsel, appears on behalf of the respondent. My lord, I'm mindful that there is the issue of the respondent's application in relation to the matter of the unagreed bundles, and I'm not sure how the court was proposing to deal with that.
The court had, speaking for this bit of the court, had completely overlooked the fact there was an application about bundles. As is almost always the case with these bundle disputes, surely the answer is just to get on with it, and if there is a particular document to which there is a principled reason for our not looking, we'll hear you at that point. Speaking for myself, I have found one or two documents in the respondent's unagreed bundle not only helpful but essential, because it's been quite difficult to work out actually what's happened in this case without access to those. And I haven't, I think, looked at, but I've seen the sort of thing it is that's in your unagreed bundle.
Yes.
So there's not going to be a problem about this in practice, is there?
My lord,
okay,
no,
well,
I'm entirely content that we deal with it in that way. My lord, this is the appellant's appeal against the order of Mrs Justice Thornton dated the 2nd of July, dismissing her claim, and as the court will know, it is an appeal concerned with the correct interpretation of the express terms of the respondent's collectively agreed and contractually incorporated policy for handling concerns about the conduct of medical staff in respect of what I'm going to term the disclosure rights of doctors when they're being investigated under that policy. The name of the policy is very cumbersome, but I'm going to refer to it as the MHPS policy because it is the respondent's implementation of maintaining high professional standards in the modern NHS, MHPS, which is the national disciplinary framework for doctors and for dentists in England. And because the MHPS policy is the implementation by this trust of the MHPS framework, it is an appeal which has implications for all doctors and all NHS trusts across England. And it is undoubtedly, I would suggest, the general importance that was alluded to by Lord Justice Bean when he granted permission for this appeal to proceed. But I do suggest that it's important to have in mind from the outset that this is a question of contractual interpretation of a collective agreement. And whilst the court is considering clause 1.16 of the respondent's MHPS policy, that in turn is a faithful reproduction of paragraph 13, part 1 of MHPS. And therefore the court is ultimately concerned with the question of what objectively did the collective parties to MHPS mean to provide for by paragraph 13 of part 1. Secondly, this, because it is a question of contractual interpretation, I suggest that analogies with different types of legal proceedings are unlikely to assist this court. This court is not concerned with whether disciplinary proceedings look more or less like criminal proceedings, and therefore whether disclosure is more or less like the sort of disclosure you would get if you were a defendant in criminal proceedings. It is looking at what contractually these parties agreed to. Thirdly, this, the court is not concerned with whether on the facts of this case the appellant does or does not need, in inverted commas, to see the disputed documents in order to be interviewed as part of the investigation. I use the word need because that's the word that Mr Gorton uses in his skeleton argument, whatever is meant by that. Much of the respondent skeleton, and indeed a good portion of the unagreed bundle, appears to ask the court to look into the ins and outs of what happened in this case and to form a view about whether it thinks this appellant would or would not be assisted by provision of the documents. but it's a task of contractual interpretation. And therefore, it's a question of what collectively the parties meant, not whether this appellant
One view of the
needs or not.
concept of, forget correspondence for the moment, the concept of related to the case might be that it means something like which the doctor or dentist needs to see for, in order for the investigation to be fair.
Well, my lord, that's not the interpretation that
Which
the
you argue.
court,
All right, no, I see that, but I
arrived
think to say that it is not, the appeal is not concerned with whether your client needs to see the document, really assumes what you have to prove. On one view, it is concerned with that. What you may be saying is that if you are wrong on that approach, you're not challenging, I don't think you are, the judge's assessment about whether the documents in question were related to the case in the necessary sense, in the sense that she thought was relevant.
Well,
correct.
No, my lord. I mean, as you will have appreciated, there are alternative grounds of 2, 3, and 4, and ground 4 does involve challenging the assessment of the court. But
well, then in that case, let's not get ahead of ourselves.
Yes.
It's my fault for interrupting, but I just wanted to put down a marker that I think it's going too far to say we're not concerned with whether the claimant needs to see the document. On one interpretation, that is a decision that we'll have to take.
Yes. Well, can I just at this stage deal with it in this way, my lord? Number one, I make that broad submission. It's not a question of whether you need to see. But my second point would be this, is that it's, and this is a point that I made below, is that it's no answer to the need to see the documents you don't have to say, well, you've seen a whole load of other documents.
No, well, that's very
because
helpful.
it may be that it is within those documents that you have not seen that lies something that actually is really rather important in terms of what you want to say at your investigation interview and potentially in due course in the disciplinary proceedings. That the mischief here, of course, the appellant does not ultimately know what these documents consist of because the respondent has refused to provide her with them.
You've mentioned in that last submission both the investigation stage and any possible disciplinary stage later. Might there in principle be a distinction to be drawn between them? Might fairness in the disciplinary stage require potentially much more than at the investigation stage?
Well, my lord, that is a point that was canvassed below. But as you will have seen from the judgment, the way that Mrs. Justice Thornton looked at it was to say, well, we'll look at what you're entitled to at the disciplinary hearing, and we will say that you can go no further than that at the investigation phase. But the difficulty, my lord, in my submission with that argument is this, is the respondent accepted these documents would never be provided as part of the disciplinary phase because they said, well, to paraphrase, we say they're not relevant, therefore we wouldn't be relying on them for the purposes of a disciplinary hearing, so you don't get them. So, my lord, and I'll come to this in due course as well, the difficulty with the respondent's argument is that it shuts the appellant and anybody in her position out of the documents, and that deficit is not made good at the disciplinary phase, and that was accepted but below.
Well, I think you shouldn't assume that we'll have to hear Mr. Gordon on that what was accepted below would be accepted by us. I'm attracted by the point, I think, implicit in my Lord's approach. What we are dealing with here is disclosure at the investigatory stage. Unless you can show that it is relevant, I think we shouldn't concern ourselves with what may happen at the disciplinary stage, beyond noting that, in principle, what happens at that stage, the requirements of fairness may be more demanding.
I take that point, my lord, but what is said by the court below is that the standard of fairness at that stage is less demanding, and what is required.
Sorry, standard at which stage is this?
The standard at the disciplinary stage is less exacting, and that
Really?
in some way.
Does the judge really say that?
Well, and it may be, my lord, that the easiest way to deal with this is to actually go to the particular part of the judgment.
Yes.
That
Well,
I
I'm
have
afraid
in
this
mind.
always happens when the bench intervenes. We don't want to take you out of your order, but I hope it's helpful. At least you'd see that what is likely not to be common ground.
I see that, but
You can do it in your own way.
yes. But just on this point, my lord. Yes, it is page 87 and paragraph 101. And it's little letter C, where the judge says this, and this is part of her reasoning about why she comes to the view that she does on contractual interpretation. She says, there is no explicit right to disclosure further along in the disciplinary proceedings, where when employment may be in peril. The MHPS pre-hearing procedures for a capability hearing provide that, quote, the case manager must give the practitioner the opportunity to comment in writing on the factual content of any report produced by the case investigator, and then she quotes a particular part of MHPS. There is no right to documents that the case manager might have seen. Prior to a capability hearing, the practitioner is entitled to, quote, copies of any documentation and or evidence that will be made available to the capability panel. There is therefore no right to see all documents, just documents on which the employer intends to rely. It would be surprising if there was a greater legal protection by way of disclosure for those to be interviewed when the matter may go no further than there is for panel hearings for practitioners facing the end of employment. If anything, it ought to be the other way round. So that is the point, my lord.
No, you're right. I hadn't really focused on that, and I don't think you should take it that I would go along with everything the judge says there, nor to Mr. Gordon.
It may or may not matter, but the judge does begin that passage with this sentence: there is no explicit right to disclosure further along that. Now, again, as my lord says, it may not in the end be necessary for us in this court to say anything about the later stage, but speaking for myself only, as a matter of principle, I might have thought that if you get to the disciplinary stage, that the rights which are in play may not be exclusively express rights.
Yes.
In other words, that it might be said that there is an implied obligation of fairness, but that what it requires at the disciplinary stage may be more onerous than what it requires at the investigation stage.
I see the point you're putting to me, my lord. Two points I think that perhaps may be of difficulty there. I mean, of course, when one talks about an implied right of fairness, then as a matter of employment law, we would be talking about the implied term of trust and confidence. There are a number of authorities which have ended up eschewing the idea of there being a general duty of fairness in relation to disciplinary proceedings. The difficulty that one gets into there is that if the contract has made express provision for what you do get, can it really be said that one can pray and aid the implied term of trust and confidence to create rights of disclosure that you do not have? And as Mrs. Justice Thornton does say at paragraph 101C, what appears to be contemplated by the parties, certainly for a capability hearing, is that you get to see essentially the documents on which the employer chooses to rely, which may not be the totality of the documents, and on this case mean they will not include documents that the appellant has not seen, even though the case investigator has seen them.
Well, this may be a red herring, as my lord said. We don't ultimately have to decide what the position would be at the full hearing, but if if you had to make a submission about it, would you submit that that the judge was right? Suppose a situation in which a case investigator or case manager puts before the disciplinary panel documents A, B, and C, and conceals document D, it might be a witness statement or it might be a contemporary document,
Yes.
which contradicts A, B, and C, and is clearly helpful to the doctor,
Yes.
that there would be no breach of contract? I would find that surprising.
As you say, my lord, it's not the situation with which we're dealing. Instinctively, however, I would say that is probably not a breach of contract, but it would plainly be unfair.
Well, now you say that there's a lot of case law, and I do dimly remember all this because, of course, it's one of the reasons why we said we had to have the unfair dismissal jurisprudence, which was before my time, but not by much. Sorry, the unfair dismissal legislation. But is there clear modern authority that there is no duty of fairness on an employer conducting a disciplinary procedure? It sounds counterintuitive to me.
My lord,
If you say there
yes,
is,
and
what is it?
I'm sure we can provide copies for the court if it would be of assistance. But from recollection, it's the case of Chakrabarti and Mrs. Justice Simler, and
At first instance.
at first instance, so Mrs. Justice Simler, as then she was, considers the conflicting case law, and it rests, to my recollection, my lord, with the case of Chakrabarti, which says that there is no general duty of fairness in the conduct of disciplinary proceedings, although, of course, you must conduct...
Well, speaking for myself, I would like to see that.
Of course.
It does dimly ring a bell that there was some, but I thought that the development of the duty of trust and confidence, to use that inaccurate shorthand, had effectively swallowed up that rather unsatisfactory line of authority.
Well,
but you say not.
From recollection, my lord, and I will make sure that we dig out Chakrabarti and provide it to the court, it is to say that fairness is if I can put it this way, a subset of the implied term of trust and confidence.
Well, all right. I mean, I don't mind if it's been
it doesn't have
categorised
an existence independent of the implied term of trust and confidence.
Okay. Well, I do think this question of the existence of a duty of procedural fairness may be quite important to the analysis of the investigation stage as well as the disciplinary stage. So I would like to make sure we weren't saying anything that was contrary to
Of course.
that line of authority, if that's really what it says. Thank you.
Thank you, my lord. Just one final preliminary observation that I wanted to make, and it relates to a point that is made in Mr. Gorton's skeleton argument, and the court will find it at page 44 and paragraph 53.
Which paragraph?
53. Now, it may be that this isn't quite what he means, but the way that it reads it caused perhaps a little concern.
Sorry, which paragraph did you say?
It's paragraph 53, page 44, my lord.
Yes, sorry, I've got it loose.
So
So
it is-
pages won't help, but paragraphs are fine. Hang on.
Yes.
Okay, yep.
Now, it is a paragraph that starts, the above pointers raised by A in support of a purpose of interpretation take A's case on interpretation nowhere. But it's the last clause, which starts 3 lines up, quite why A needs a panoply of documents in order to justify why she did not fulfil her contractual on-call duties with regards to PA is nothing short of mystifying. That, my lord, struck us as a rather troubling submission in a case in which the investigation is on hold, pending this court's determination of the appeal. And in any event, of course, the point is that what the appellant wants to see and what we say that she is entitled to is that which she has not seen, not what she has seen, so that she can, when she comes to give her view of events at an interview, discuss those matters as well. If it's convenient to the court, I was proposing to deal with my submissions in the following way. First of all, I was going to look at some overarching principles on interpretation which are relevant to all the grounds of appeal. Then I was going to deal with the grounds of appeal in turn. I think it was Lord Justice Bean who observed that they're interrelated, but they are distinct grounds of appeal. And as I've already alluded to, 2, 3 and 4 are all in the alternative to each other. And then finally to say something about the respondent's notice that has been put in by Mr. Gorton. So if I can start with the principles. So just bear with me one moment before I do that. Mr. Jones has very helpfully just handed me a note, my lord, on Chakrabarti, where it's dealt with in Greg. I'm very grateful to him. It's so can I just deal with that to finish off that particular point, my lord. It's page 488 of the authorities bundle, and it's paragraph 97.
Moment. Sorry, I missed that.
Page 488, paragraph 97.
Thank you.
And so this is part of the judgment of the court in the case of Greg. And at paragraph 97, Lord Justice Coulson says, there has been a certain amount of debate in the cases as to whether there is a separate obligation on the part of an employer to act fairly. The authorities suggest that there is no freestanding obligation to act fairly which is separate from the term of trust and confidence, see Chakrabarti, and Ipswich Hospital NHS Trust, and in Braganza and BP Shipping, Baroness Hale referred to the approach in judicial review cases and explained
Well, I think okay, that's a different point, isn't it? Well, okay, well, we still better read Chakrabarti,
yes.
But that suggests that my recollection was roughly right, that as a matter of taxonomy, the duty of fairness has not been recognised separately.
Yes, my lord.
But that it has been subsumed into the term of trust and confidence. I mean, speaking for myself, I find all of it theoretical. But still, if that's the way the law has gone, we can get a sensible result by following it. But I'm grateful to Mr. Jones. That's a teaser, but I think we still need to read Chakrabarti. Speaking for myself, I'll try and do it over lunch, but if you can get a copy for us, that would be
well, I will, of course, and I'm at least grateful to him that I've correctly remembered that it was Chakrabarti. And
no, everybody comes well out of this.
Thank you. So I was just about to turn to the first of my themes, and that of principles, and to ask the court, if I may, to turn to the judgment. And it's page 69 of your core bundle, and paragraph 11, where the judge sets out relevant principles of contractual interpretation.
Yes, I mean, I obviously don't know what points you're going to make, but surely we can take this fairly fast, can't we? I mean, I don't think there's going to be much controversy about this, but still.
Well, I would hope so, but the skeleton argument from the respondent may suggest that there is.
I see. Okay, well,
but in any event,
say what you have to say.
At paragraph 11, she sets out the principles of contractual interpretation that she notes are common ground. And then over the page at letter E, she refers to the case of Smo and Howell Var and says that the courts adopt a purposive approach to interpretation so as to enable sensible procedural decisions to be taken. Interpretation should recognise that disciplinary procedures provide employees with an opportunity to justify themselves in relation to allegations of misconduct or incompetence or other criticisms of them. They also provide safeguards against loss of congenial employment and potential career damage consequent upon dismissal for such reason. So the purpose of MHPS recognises the importance of the procedural protections to the...
But isn't the previous subparagraph at least as important? That part of the purpose is to ensure fairness.
Yes. Yes. But fairness to the doctor,
Well,
recognising...
certainly fairness to the doctor, but a fair procedure recognises the interests of everyone involved.
I take that point, my lord. I suppose what we would say here is that the fairness to the doctor is not even recognised when one side has the documents and the other does not. And
May depend how relevant the documents are, maybe. But
well,
anyway, sorry, that was prerogative. You want me to keep going?
and as is recorded there was no dispute below that a purpose of construction was the right one to adopt, and that is what Mrs. Justice Thornton rightly said should be done, but we say she failed to adopt that approach in practice. Now, it may be, again, a matter for Mr. Gorton, but page 36 and paragraph 24 of his skeleton argument, and this again is in the core bundle, suggested that he might be taking a different approach. Because he has, above paragraph 23, the heading interpretation generally. And then
I'm so sorry, I've just got behind again.
So
Which paragraph are we on?
Page 36, paragraph 24. And this is where he deals with what he terms interpretation generally. And at paragraph 24, and this is the last sentence, he says, there is accordingly no need to deploy any method of interpretation other than the natural meaning of the relevant clause, which appeared to us to be going behind what was common ground before, below, forgive me, that it should be a matter of purposive interpretation.
All these debates about interpretation tend to run into the sand. I'm not sure that a purposive interpretation is necessarily different from the natural meaning, but the natural meaning has to take into account the overall purpose of the document. So well, this all.
Insofar, my lord, as there might be said to be a tension between them, then the natural meaning has to give way to the purpose of the contract. It may be that as a matter of dictionaries, as is sometimes said, that a word means something in particular, but if you had regard to the context and the information available to the parties and the purpose that you're seeking to achieve, that is not the interpretation.
Well, this is all material which the Supreme Court has. I can't resist Lord Justice, the former Lord Justice Jackson's observation about this being an area in which the Supreme Court has, over recent years, favoured us with a number of judgments, each one helpfully explaining what the last one meant.
Indeed. Quite. But if one looks at the case law, and I will briefly, if I may, just ask the court to turn up some of the authorities on MHPS, then I would suggest, my lord, that there are two major themes which arise from that case law. First of all,
before you move on, Ms. Criddle, I'm sorry to interrupt.
Of course, my lady.
May I just ask you about one of the factors that may be relevant when interpreting this document? I mean, there's a lot of emphasis on fairness and fairness to the doctor, but isn't one of the relevant factors also patient safety? Because the whole point of MHPS is to deal with concerns about doctors.
My lady, I wouldn't suggest for a moment that MHPS is not concerned with ensuring that matters are properly investigated, and if the conduct or capability of a doctor gives rise to concern about patient safety, that of course is something that needs to be investigated. But it needs to be investigated fairly, and having regard to the right, and no one has suggested that this is not a right that a doctor doesn't have. It's a right to be interviewed, it's a right to give a view of events. And we say that inherent in the concept of having a right to give your view of events is the ability to see and to comment on the documents that relate to the case. And if one might think of it in this way, I mean, in terms of fairness to the NHS trust, what, might I say rhetorically, is the benefit to an NHS trust of keeping all of its cards to its chest and saying, we don't have to give you anything because we don't have to give you...
That's not this case, is it?
No, but if they were to say, we don't have to give you any documents because that's not correspondence, we don't have to give you anything that we don't think subjectively is relevant, how does that, I say, help the trust? Because the trust may then find that it has formed an erroneous view of the case, which if only it had shared the documents with the doctor, it might not have made. And therefore it puts a lot of people to the time and trouble and anxieties concerned with full-blown disciplinary proceedings that were never necessary in the first place.
And may I ask another question, please, about the factors that are relevant to a purpose of interpretation? My provisional view, having read the MPS, is that one of the factors that the drafters, the collective parties, thought was important was speed. So there's a time limit for the investigation stage, which can be breached in appropriate cases. But would you accept that when we're interpreting this document, speed of procedure is also a relevant factor?
It's a relative factor. It's a relevant, forgive me, my lady, factor, but it's not a determinative factor.
No,
fairness is what matters more than anything else.
But what if there's a tension between patient safety, speed, and standards of fairness? Do you say fairness wins out?
I don't, for my part, my lady, see that there is a tension between them, because to take your ladyship's instance of speed here, one of the things that is said against us is, well, it's all very difficult, isn't it? It's all very difficult if we have to give the doctor all the documents relating to the case. Well, why? Why is it so difficult? All those documents will have been gathered together and given to the case investigator. What is so hard about putting it all through the scanner and sending it to the doctor? The doctor then looks at it, and the doctor is then interviewed with it before him or her. So I don't, for my part, see there's a tension between those two things. And, my lady, to take your other issue of patient safety, again, I don't see that there is a tension between patient safety and fairness to the doctor, because surely, in order to uphold patient safety, you want to get to the bottom of what's happened. And getting to the bottom of what's happened will surely entail the doctor being able to give a full and proper account of events.
The trouble is about absolutes. One of the complications is that actually the trust has followed exactly the approach you say they should have done in this case, except for three documents, or 6 documents, depending how you look at it, but where there have been problems about confidentiality and getting the consent of the other parties who arguably have an interest. Now, the way the case has developed, it's not for this court to determine whether those concerns were genuine or were well-founded.
Yes.
I'm sure they were genuine, but suppose they were well-founded, you might have a situation in which at the investigative stage there were documents that you did, which you were perfectly happy to show, and which were, certainly on a broad view, related to, but you just didn't feel conscientiously you were able to show. Now, if the overarching test were fairness, you might have to say, well, ideally, the doctor should see this, but we're going to have a major battle to get the consent of the third party to allow them to do so. So in the meantime, we'll not show them the document. We'll go as far as we can to tell them what's in it. And we will have to reach our, conclude the investigation on the basis of a slightly unsatisfactory situation, because we've not been able to give the doctor everything on that point. And then there may have to be a further battle at the disciplinary procedure stage. But that sort of suboptimal situation is bound to happen sometimes in real life. And the ultimate test should always be, what did the employer act fairly in the circumstances with which they were presented? Now, I'm not asking you to address the facts of this case. I'm merely taking them as an illustration.
Yes.
But in the real world, most trusts are going to do exactly what you say. They're going to hand over everything because it's much easier. They've got the disclosure file. They'll just photocopy the lot, and that was Miss Shaw's. Sorry, was it Miss Shaw's? No, Miss Wood's initial reaction. And the only reason you didn't get them all was that there were problems about confidentiality.
Not quite, my lord, without wishing to delve too far into the details of this case. But can I just deal with that, and then I'll deal with the points of principle that you raised with me. What actually happened in this case was that when inquiries were made, and they were made repeatedly about documents, the answer that initially came back was, well, we think you've seen everything we've got to see, so no point was taken. But then, when then ultimately a list was provided, and it became apparent that there were many, many things on the list the case investigator had seen that the appellant had not, and then there was a request for them. And then, and I can take you to it if
Well, it took about a couple of months before you got most of them.
Yes, but the
ones you then didn't get were only the ones about which there was a confidentiality concern.
Not quite, my lord, again, because what happened was that the trust said, we're not going to give you these documents because we don't think they're relevant.
Well,
but they say, we think that we may be able to find a way through this, and we'll go and ask for consent.
Yeah.
But consent is not the reason for not providing the documents in the first instance. It's we don't think they're relevant. There's a
but in a sense, they're forced back on that, on one view of the rules, not for this. But neither side's bound by the position that people took in this slightly confused correspondence that went to and fro. The position may well be that we don't think this is relevant, but in order that you don't feel aggrieved or think we're hiding everything, we'll give you everything relevant or irrelevant, except where there's a confidentiality problem.
Well,
and that, whatever their position may have been as the correspondence emerged, that's really where it all ended up at the end of it all, isn't it?
Again, my lord, I'm not sure that is exactly right. There is an oddity about this case, that the respondent tells us that there's pretty much nothing to see here. And if that was so, you might think to yourself, well, why didn't they just give us the documents? Because if no one was...
But they've explained why they didn't give you the documents, because two of them are letters to the parents, and the parents have said have not given consent. And the remaining three are witness statements from the root cause analysis, where 11 of the 14 have given consent, but 3 haven't. Have I not got that right?
My lord, you are right about that, but the only reason that consent arose, consent was step 2. Step 1 of the respondent's approach was to say, we do not think these documents are relevant.
I know, but you've made that point, and I do see it. But for myself, the position we have reached now is, and actually reached quite a long time ago, is the trust were willing to give them to you relevant or irrelevant, as long as there wasn't a consent problem.
Well,
and the only ones which they said are not relevant are the ones for which there was a consent problem.
Well, what I think they say is this: we'll give you the things that we say are relevant. We won't give you the stuff that we say is irrelevant, but we will ask for consent, and we will give you things which we consider irrelevant for which we have consent.
I think that's roughly what I said.
Yeah, but the point, my lord, is this: consent is the data protection issue, which has been the red herring that has stalked this case from the outset. The respondent has consistently waived data protection in what I say is a very in an imprecise way, because if one actually looks at the GDPR, consent is only one basis for disclosure, and if it were necessary for the trust to provide these documents to comply with their legal obligations, that is a perfectly lawful basis for processing these documents. Consent is not a trump card. It cannot be used to override what is actually provided for in MHPS, which we say is a right to disclosure of documents.
But for better or worse, that's not the way this debate has come before us. We can't decide whether the consent objection was a good or bad one, because that's not the way it was decided below.
My Lord, I'm not suggesting for a moment that it's for this court to decide whether the consent objection, that consent was validly or invalidly dealt with. What I do say, however, is that consent is not a trump card, is that what one has to do is to actually analyse the obligations under MHPS and therefore the trust's policy, and then to say to oneself, is this a legal obligation on the trust to provide disclosure? If it is, then consent is immaterial. Frankly, the trust should never have embarked down the route of consent. Confidentiality, my Lord.
I'm not blaming you, because I sort of raised the point, and I don't, I'm sure your client feels strongly about it, but ultimately, you've made your point.
Thank you.
And I don't think there's
what I was just about to move on to, my Lord, was the other point that you raised with me, which was that of confidentiality. Confidentiality is a different topic, and Mr. Gorton makes a number of submissions about that, and I can deal with this very shortly. Confidentiality might, for instance, require redaction of particular information, because I accept that there may be competing rights, and for instance, it may be that somebody is a whistleblower and says, I don't want my identity to be known. That might be a situation in which you would have to redact the identity of the complainant in order to do justice as between the parties. That, however, doesn't touch on the central issue with which this court is concerned, which is that of a right to disclosure of documents. That, in my submission, remains unaffected.
Yes, I think how we got onto all this was I was putting to you really as testing what the governing principle should be, and picking up on something my lady had said about this only being the investigative stage and,
yes,
and intended to be quick. You might sometimes get a situation in which there were genuine problems, maybe the ones we've been looking at, all I know, other problems about physically getting hold of documents or whatever, where it would be fair, even if not ideal, for the investigator to conduct an interview and reach a first stage conclusion without the doctor having seen every document that the doctor wants to see. It would all depend on the circumstances of the particular case. We shouldn't be dealing in absolutes.
Well, my Lord, when one is looking at a question of contractual interpretation, in a sense, one is dealing with absolutes, because one is saying, what does this clause mean? Does this clause provide for a right to disclosure? Because if it does, then it isn't a question of fairness as such. And of course, the court will know that this isn't before your lordships and your ladyship as a case on the implied term of trust and confidence. It's a case that's before you on express terms of the contract. So that is ultimately.
I understand that, but the express terms need to be construed in the light of the general obligations of the parties, and so far as possible, so as to fit with those general obligations. What the obligations would be, it's very difficult to read 116 as intended to be a statement of the disclosure obligation in at the investigative stage. Very unlikely to be comprehensive. So one needs to see what the overall obligation is and then fit this specific obligation into that context.
My Lord, I wouldn't disagree, of course, that one has to look at clause 1.16 in context. One has to look at it within the context of MHPS as a whole. One has to look at it within the context of the obligations of the parties as a whole. But if the proposition that you're putting to me, my Lord, is that you can use fairness to water down what's in clause 1.16, then that is where I think I would part company, because 1.16 is part of a bundle of rights that is afforded to the practitioner at the investigation stage. And of course, I know the court will have well in mind that this policy is the replacement for HC 99, which was a full-blown inquiry process with disclosure, with the ability to challenge evidence at the investigation phase through cross-examination and to have findings of fact made, is it really to be suggested that that whole edifice has been swept away and replaced with nothing?
Well, you may well want to make detailed submissions about that in a moment. I saw that point being made, but I haven't been through it. My immediate reaction is that there was a very deliberate policy intention to make things simpler and less rigid than HC 99. Of course, it goes without saying that there must be an intention that the procedure as a whole should be fair, but that does not mean that every protection contained in HC 99 should be carried over by implication, if it's not express, to MHPS. The two, you must remember, or perhaps you eager remembers, so long ago, there was a lot of discontent with HC 99, primarily by trust, but sometimes also by doctors, because it all went on forever. It was perceived as being too legalistic, and MHPS was thought to be less legalistic, and was drafted in a chatty style so as to deter lawyers from taking legal points.
And yet here we are.
A slightly misconceived approach, I always thought, but still.
Yes. And of course, my lord, I don't suggest that for HC 99C MHPS, of course not. I don't suggest that for a moment. But when you are, and I'll come on to this one, mindful of time, is that when one is looking at a question of interpretation, there may have been a break with HC 99, but there's not been a break with fairness. There's not been a break with the underlying concept that doctors should be able to provide their view of events at the investigation phase. It's just that somebody different is doing it now. My lord, unless I can help the court particularly on this point, I'm proposing to move on just because I'm mindful it's of the time and we are set down for a day.
No, that's fine. I think we've covered actually, or trailed quite a lot of the points we're going to be coming to later.
I suspect that I have.
Yeah.
So I was.
My lady has.
I'm so sorry, my lady.
I'm so sorry, Ms. Krill. Before you move on, I wonder whether it might be helpful if the parties could provide us with the disclosure obligations in HC 99 so we can, at the investigation stage, just so that we can see what they were.
I will endeavour to track down a copy. It's one of those things, my lady, which I gather is a little like looking for the Holy Grail these days. But I think I have an idea of where I might be able to get one.
That's very helpful, thank you.
Of course. But the case law, which I'm going to take the court to as swiftly as I can, I say, in the context of MHPS, talks about two principal themes. One is fairness in operating the MHPS framework, but the other is this. And it goes back to the point that you were putting to me, my lord, about the chatty style of MHPS. It is not in all respects a model of drafting.
It's not in all respects
a model of drafting.
No.
And in interpreting that framework, the court must nevertheless identify the purpose to which the collective parties are seeking to give effect, even where that may mean departing from the literal wording of the framework. And one of the cases that I want to take the court to in particular is called Carney, in which this court does rather a lot of work with some bad drafting of MHPS on the question of the right to legal representation. But to deal with the authorities relatively swiftly, as I say, first of all, in the authorities bundle, the case of Kerslake, which should be behind the court's tab 8, you don't have tabs, but it's page 187 in the pagination at the bottom.
Yes, can I just make that point very briefly? It does help to have tabs, and I don't know who is responsible for the authorities bundled together, but can they learn a lesson?
Yes, and I can only apologise on
No, I don't want to make a fuss about it, but since you mentioned it. Yep.
But it's 187, my lord, and it's the case of Kerslake.
The decision of Judge Curran.
It's the judgment of Judge Curran, sitting as a Deputy High Court judge, and he says at paragraph 150, he makes a number of points, but the first one is that MHPS is self-evidently of major importance to both parties in dealing with conduct and capability concerns. It of similar importance to all NHS doctors and employers. Matters of conduct and capability are of very serious import to a medical practitioner's reputation and employability within the NHS, and thus MHPS is of crucial significance to the contractual arrangements between the claimant and the defendant. It is a nationally agreed framework which specifically and expressly replaced all previous disciplinary procedures in the claimant's contract of employment. So the words there are of crucial significance to the contractual arrangements. And somebody has very helpfully managed to print
Yes.
about it already.
Very impressive. Up to you whether you want
I
to
will,
go to it now or later, whatever
if I may, I know the paragraph I'm looking for, but if I could continue with this particular thread,
let's
I'll
stick
come
with
to it
this.
if I may.
Yeah.
Then the next authority that I wanted to take the court to was that of SMO. The case starts at page 498, but the particular part I wanted to take the court, if I may, was at page 512.
This is Mr. Justice Linden.
This is Mr. Justice Linden. Now, I'll say at the outset, this was a case not about MHPS, but about its Welsh equivalent, upholding professional standards in Wales. But for these purposes, the task of interpretation is the same.
You were in this just as you were in
Yes, yes, I was, although
you were for the other side. Yes.
well, the best traditions of the bar and all that.
Of course.
So paragraph 124 is where a number of submissions were made to Mr. Justice Linden about how to deal with a purposive approach. And first of all, reference to the judgment of Lord Stain and Skidmore, advocating a broad and purposive interpretation enabling sensible procedural decisions to be taken. Little 2, a reference...
Skidmore, I think, wasn't... That was about an HC 99, wasn't it?
That was... You're absolutely right, my lord. That Skidmore was an HC 99 case. Griff-Luxowski then is referred to a little 2, and the judgment of Mr. Justice Gray pointing out that disciplinary procedures provide employees with an opportunity to justify and vindicate themselves in relation to allegations of misconduct or incompetence or other criticisms of them. They also provide safeguards against loss of congenial employment and potential career damage consequent upon dismissal for such reasons. And then little 3 is the passage from Kerslake, to which I've just taken the court. And then at 128, Mr. Justice Linden says that the context in which the provisions were agreed is also important, i.e. one in which there is a public interest in the effective and efficient management of the conduct, capability and performance of medical professionals, which of course is the point that my lady was putting to me. But there is also potentially a great deal at stake for the practitioner, and the procedure may provide them with an opportunity for vindication. And then skipping over the parts that were particular to that case. Finally, and this is five lines up from the bottom, I should work on the basis of the parties to UPSW, for which read here MHPS, considered that it struck a fair balance between these important, potentially competing interests, or at least that the faithful application of the procedure would ensure fairness. And then, just whilst we are here, could I just ask the court to turn forward to page 518, please, and paragraph 183 of the judgment in SMO. It's a different point, but it's just convenient to take it here.
Yes.
In SMO itself, which was all about whether it was a case of conduct and capability or whether it was a case of a breakdown in working relationships, that the parties put a number of unfair dismissal authorities before Mr. Justice Linden. And he noted, and this is paragraph 183, the first issue which I have to determine is one of construction of the particular contractual terms under consideration. The case law relating to the interpretation of some other substantial reason is therefore of limited assistance, albeit I accept that the case law in the field of statutory employment protection recognises that the same factual situation may give rise to different concerns, as I have discussed above. I raise that only at this point because Mr. Gorton seeks to draw analogies with the ACAS code and to say, well, because the ACAS code, he says something different than is said by this contractual provision, that somehow is an aid to interpretation. It is not. You have to interpret the contract not look to other sources which deal with different things.
Not quite sure that's the point he's making. I think the point he's making is it's a bit surprising if the doctor in this case is entitled to more than you'd get under the ACAS code. I think that's a slightly different point.
Well, my lady, the point that I hope I'm making is to say this, is that when you're looking at a question of contractual interpretation, that is what you are doing. And of course, it's perfectly open to parties to contract for whatever they want. I mean, they can't contract for anything that is inconsistent with the statutory regime, but there is nothing that is inherently wrong or surprising, particularly when you're talking about professional employees, particularly when you're talking about the implications of adverse disciplinary findings, that the collective party should have said, we think we ought to do better than the statutory minimum when we come to look at our particular bargain. I said that I would turn to Kilcarney, but just before I do that, I wanted to look very briefly, if I may please, at the case of Anderson. It's a very short point, but it's about the interpretation of collective agreements. And in particular, it is page 263 of the authorities bundle that I wanted to look at, please.
So which page did you say?
263, my lord. So this is not an MHPS case, but it is a case about the approach to construction of a collective agreement. And at paragraph 14, Lord Justice Maurice Kay makes reference to the very well-known dicta in West Bromwich, one of the, as you say, my lord, the multiplicity of cases from the Supreme Court on the question of contractual interpretation. And it's the very well-known statement of principle that interpretation is the ascertainment of the meaning which the document would convey to a reasonable person, having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. Number 4, however, might be worth just drawing attention to. It is to say that the meaning which a document would convey to a reasonable man is not the same thing as the meaning of its words. The meaning of words is a matter of dictionaries and grammars. The meaning of the document is what the parties using those words against the relevant background would reasonably have been understood to mean. So the fact that one can go to the dictionary and say, well, this word means this, matters not if you're looking at a document in which it is apparent that the parties meant something else. Because what you have to do is look at what the parties using the words against the relevant background would reasonably have been understood to mean. And the background may not merely enable the reasonable man to choose between possible meanings which are ambiguous, but even to conclude that the parties must, for whatever reason, have used the wrong words or syntax. Then at paragraph 15, the court makes reference to the context here being that of a collective agreement. And then at paragraph 16, cites the judgment of Adams and British Airways, and essentially a short circuit says you interpret a collective agreement just as you do any other contract. But what the court does say, and this is at paragraph 22, it is, and I fully accept, a judgment about the particular collective agreement. But the court asks itself, what meaning would the pay conditions agreement convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the agreement? And enriching that construction, and this is the very last sentence, the court eschews a construction that flouts industrial common sense. If it doesn't make industrial common sense that the parties should have agreed to a bargain that is being now contended for, then that is a guide to how you interpret the document. Then finally, I said that I would go to...
Just so that you're aware of it, I don't think we need to go to it. This isn't the most recent case on construction of collective agreements. There's the Nexus case.
My lord, you're right.
Maybe I can't remember whether we went into this degree of of principle, but we did say something about, in fact, the phrase there used was commercial common sense, but it's the same point. Sometime, when we said there, sometimes you've just got to go by what the words were. You can't, in reference to commercial common sense, doesn't mean that people can be relieved from bad bargains on the basis that they didn't realise that was the effect of what they were agreeing to.
My lord, of course, that must be right, but when you are looking at what the parties are taken to have meant, then the fact that a particular construction doesn't seem to make industrial common sense is a relevant consideration in the exercise of construction. I then said that I would go to Kulkarni. Kulkarni is a decision of this court, and it starts at page 19. The issue that was before the court was...
Hang on, I haven't got there yet.
Oh, forgive me, Lord.
Yes?
The issue that was before the court is identified at page 22 and paragraph 1. And it was about whether or not there was a right to legal representation in disciplinary proceedings. And then the court, and this is page 28, starting at paragraph 29, the court deals with the history of the introduction of MHPS. I'll try and deal with this as quickly as I can, but it does make some, it is of some relevance because it was not published as a coherent whole. What one can see, and this is reference to paragraph 29, was the publication of MHPS on the 29th of December 2003. At that point, it was only two parts. Part 1, which dealt with the investigation phase, and part 2, which was about exclusion, what people more commonly refer to as suspension from work. And at paragraph 30, there is reference to a particular provision in paragraph 14 of part 1, which deals with the right of legal representation. And then over the page, the court at paragraph 33 refers to the fact that negotiations continued after the publication of parts 1 and 2. And what then ensued, and this is paragraph 35, was the promulgation of parts 3 and 4 and 5. 3 to deal with misconduct, 4 to deal with capability, and 5 to deal with health. And then at 36, it deals with the fact that rights of representation are covered again in part 4 of MHPS, although nothing is said about them in part 3 of MHPS. And so, and then the court, and then again over the page at page 40, note that there are differences between paragraph 22 of part 4 and paragraph 14 of part 1. They don't say the same thing when it comes to the right of legal representation. So how do you deal with a situation in which part 1 says one thing, part 4 says another, and part 3 is entirely silent on the question of the right of legal representation? And the court then goes on, and this is page 32, paragraph 48. They seek submissions on the absence of any express provision as to representation in part 3, which dealt with misconduct hearings, and the presence of quite detailed expression provisions in part 4 in respect of the capability hearing. Ms. Lee accepted that it would be illogical to provide the practitioner facing misconduct proceedings with a lower level of protective representation than one facing capability or health proceedings. Mr. Stafford also accepted that, and I agree that must be correct. It follows that paragraph 22 of part 4 must be taken to all types of proceedings. Also, insofar as there are differences between paragraph 14 of part 1 and paragraph 22 of part 4, the parties appeared to agree that the later paragraph must be taken to be definitive. And then they say at paragraph 49 that in the light of those concessions which the court considers correctly made, then the contractual rights to representation are as set out in paragraph 22, whatever the type of concern. So you would think that that was enough for the court to be dealing with. But it also then had to construe exactly what the provision in Part 4 meant. And at page 34, paragraph 57, they note that it's the task of the court, when construing a contractual term, to decide objectively what it means. And they say at 58 it has to mean objectively considered what you are taken to have agreed. And then at 59 they say, in my view, properly construed, paragraph 22 permits a practitioner to be represented by a legally qualified person, employed or retained by a defence organisation. Retained by must include instructed by. And at paragraph 60, they say, in my view, the expression not representing the practitioner formally in a legal capacity is devoid of meaning, because what it was said was you have the right to be represented by a lawyer, employed or retained by a defence organisation, not representing the practitioner formally in a legal capacity. And effectively what the court says was that's devoid of meaning, and that once a lawyer is in, then a lawyer can do everything in terms of using the professional skills for the practitioner. And I put this case before the court not because it deals with the same clause with which this court is concerned with, but because it shows what I say is permissible when construing MHPS. You can sift through competing provisions to determine which you consider to be the relevant clause. That's what the court did when looking at Part 1 and Part 4. You could apply the relevant clause to a factual situation which it doesn't address, because it would be irrational to do otherwise. That's what they do when they apply the right of representation at Part 3. But also, and perhaps most importantly here, you can read out words where they do nothing to advance the meaning of the provision as interpreted by the court. And it all goes back, in my submission, to this, that the court is not reading the words of MHPS in a purist way by reference to a dictionary. It's interpreting what the clause means, having regard to all the facts available to the parties and in light of the expressed purpose of MHPS. To put it another way, the court is looking for the interpretation that best fits the purpose of MHPS as has been identified by the case law. That then brings me on to the grounds of appeal. And the first ground relates to the meaning of the word correspondence. And I know that the court will have this in mind, but on the basis of the judgment of the court below, this ground relates only to the statements, the RCA statements, and not correspondence with the family, because the claimant, or the appellant here, succeeded in showing that the correspondence with the family was correspondence, but lost on the question of relevance. But on the question of the statements, the defendant's pleaded position was that the statements were relevant, but the issue, therefore, on which the appellant lost was the question of correspondence.
You're saying the defendant's pleaded position was that the statements were relevant?
Yes.
Yeah.
And I don't think I need to take the court to it now, but for your note, it's paragraph 23.3 of the defence.
Well, but that's not the basis on which the judge decided it.
The judge took it rather more broadly than that, because the judge, I accept, referred to the evidence of Ms. Wood and said, two are relevant, one is not. The pleaded position of the defendant was that the statements were relevant. In any event, my lord, even if you were to take the case on the basis decided by the judge, it was still conceded that two of the statements were relevant, and therefore the only reason that the appellant lost on those statements was the question of whether or not the statements fell within the ambit of correspondence relating to the case. Now, it appears to be suggested by the respondent that the appellant has sought these documents, and only these documents, as some sort of tactical gain, in order to make the case look more reasonable than Mr. Gorton suggests that it otherwise would be. I won't spend a lot of time on this. The court will have gathered, however, from the judgment that the reason that these documents were asked for was that these were the documents that were on the list of documents that the appellant had not seen, and therefore the documents that she asked for.
Audit it, we'll never know if that list had not been provided.
If the list had never been...
Who knows what? MPS obviously knew that there was the root cause analysis and probably did know that statements had been taken in relation to it, or could have guessed that they were, and might have asked anyway, but we don't know.
Well, my Lord, again, without wanting to sort of get too embroiled, the RCA report itself only sorry, forgive me. No, I was about to make a bad point. That's not right. But on the broader point, my Lord, of the list, that is one of the difficulties in my submission with Mr. Gorton's analysis, because if you don't happen to be persistent and ask for a list, you will never know what is in the possession of the case investigator, and you will never be able to comment on it. And if it's then not used at the disciplinary phase, it could be important documentation which you will have been deprived of for the duration of the entire process.
Can we just, because this puzzled me slightly, and maybe necessary just for judgment writing purposes, to understand exactly what happened, can we just, before you get to your submission, understand exactly how the list came about?
Yes.
And
So,
this is the respondent's bundle. If I can do it my way, and you can tell me where I've misunderstood. If we go to tab 35, I think it is. Yes, it is. I think tab 35.
as I'm working electronically, can I have a page number?
Oh, sorry, 532.
532. Grateful.
The list forms the second half of a document, or the second of a page of a document that starts TOR 7.
Yes. If I can.
Well, can I just again tell you my
course.
concerns? It's, although nobody has really explained this properly in anything we've seen, I think I've worked this out. There were, in fact, numerous subject matters of investigation, to put it that way. The only one we're concerned with is, and they are denominated TOR, standing for terms of reference, 1 to 7. Maybe there are more than 7, but certainly there are 7. We are only concerned with TOR 1, which is concerned with the decisions taken by the claimant on the night of Sunday the 3rd, going into the small hours of Monday the 4th. And rather oddly, we have got the letter of the 24th of something or other, January 2020, saying we're going to investigate you. But it isn't the one that's relevant to TOR 1, is it? If you look at, sorry, 30th of January, if you look at 454.
Yes. My Lord, there's I think, my Lord, you're working with the number at the bottom. I think it's been taken from
Is that not the right one?
No. I think that's just the number that's been taken from the trial bundle. My Lord, 454 is the letter notifying the appellant of the decision that there was going to be an investigation. You can see that from the first paragraph. In the second paragraph, deals with the decision to restrict her practice.
Yes.
It refers then to reviewing in detail the independent report completed by Dr. Robert Campbell. This report highlighted areas of concern around decisions you made concerning the
I
conduct of
think
this
I
patient.
see. So
That's
really,
the reference to patient
you
experience,
can't,
right?
TOR1, or it's not called that in this letter,
Is that?
it comes out of the Campbell report.
It does, my lord. And then, in
Yes,
addition,
I
are detailed concerns relating to.
Yes, and those are other
And
matters.
my lord.
Where do we actually get the statement of the 7 TORs?
The TORs, my lord, 464. That's the letter that follows a couple of months later, 4th of March.
Yes, I
That's
see.
reference
Although they're
as
not
follows.
numbered, there are
They're
seven.
not numbered.
seven
These
bullet
these
points.
are they, and number 1 is the.
Okay, that's extremely helpful. I'm sorry. This is it's all just background, but it enables just to explain how all this came about. Okay, so then we go back to where we were, which is 537. No, not 537. Sorry, 532.
Yes.
Oh, I see. So this is an attachment to the email at. Sorry, I'm working it out as I go along. I thought I'd managed it, but at 5:30.
Not.
It says, "Dear Lisa and Sasha," so that's the claimant and her representative.
Yes.
Thank you for these attachments. I'm not sure. The
No,
first para isn't relevant.
No.
But then I have attached a document which details the concerns regarding the MDT TOR7. Also, I have attached the list of documents we have access to for TOR1 along with the. I see. So that's what we see at 532.
And then, my lord, it may help you if you're sort of just tracking this through. Is that you then see at 536 again, just working with the numbering at the bottom. There's an email the 21st of July from Ms. Jones to Ms. Wood.
No, I've done all that. From then on, it's all clear.
Yes.
What I just wasn't sure was how 532 came about
Yes.
and what you were told about why you were being sent this list of documents. And this is what I hadn't seen. It's the second para at 530, which doesn't really say why it's sent you. It just says these are the documents I've had access to.
Yes, it may help, my lord, to jump into the judgment of the court at this point because they look. Mrs. Justice Thornton deals in some detail with the MHPS investigation. That correspondence doesn't come out of the blue. There have been multiple.
I'm sure. No, that's fine. I don't want to go any more in detail.
No.
I just want this little bit of narrative. So the reason why Dr. Wood sent Professor Wood, is she Professor Wood?
Doctor, I think.
Ms. Wood, I'm sorry.
Ms. Wood.
Why Ms. Wood sent this, she was cross-examined about and the judge summarised her evidence. She did it in the interest of transparency. So but the point is, it's not actually said, here are some documents I feel obliged to send you. It's all a bit looser than that. Okay, I'm now fully in the picture factually.
Yes,
Thank you.
no,
Right.
And
now you can go back to what you were wanting to address.
yes, and my lord, again, I don't want to take up the court's time necessarily with this, but at page 73 of the core bundle, the judge deals with the course of the MHPS investigation, which is what we've just been looking at with the documents themselves. Paragraph 31 is being told of the decision to investigate. 32 is being contacted by Ms. Wood to come to an investigative interview. And then over the page at 33 is the beginning of the correspondence about the documents. And there's an
No, I have read all
and
this.
so on.
I'm aware of all this. What I hadn't just pinned down was
Yes.
where the terms of reference came from. And
Yes, of course. And just on this point, my lord, then it's I've referred to a couple of times, but just so that you have it, paragraph 35 is the email of the 13th of July, in which it is said, on behalf of Ms. Wood, we do not believe that we have seen any documents that Ms. Byrne has not. So that at that point in time, certainly there was not a conscious decision to withhold these documents.
Yeah.
In fact, it was believed that she had them. And then you will have seen what then ensues from paragraph 37 to 40 about the initial dealings with.
I have indeed, yes, thank you.
Thank you. But the point I was just making was that it is not as though the appellant has chosen only to ask for some documents from en masse. She has asked for the documents that she's been told exist and which she has not seen. And it appears to be suggested by Mr. Gorton in his skeleton argument there may be some other documents. If there are, we've not been told they exist, and that is doubtless something that we'll need to follow up separately. But I wouldn't want it to be thought by this court that there was some tactical decision behind the request that was made. He makes one point which I will pick up when looking at the clause about interview transcripts and whether we'd be entitled to see interview transcripts. But if I can then turn forward to the judge's analysis, and this is paragraph 97 of the judgment at page 85. Where she starts to deal with the question of interpretation of clause 1.16, and she says that the natural and ordinary meaning of correspondence is an exchange of written communications, as for example by way of letter, email or similar. In my judgment it has a distinct and separate meaning from the broader term document. As I say, that is the sole basis upon which the claimant loses in relation to the RCA statements, or at least two of them, which are accepted by the defendant and by Ms. Wood as being relevant. And in my submission, it is abundantly clear that that is a literal dictionary definition of correspondence. That is what Mrs. Justice thought.
I'm so sorry. Can you just show me where the reference is to two of them being relevant and one of them not?
Yes, of course. Forgive me.
68, I think.
Very grateful. Is that page or paragraph number?
Paragraph.
Thank you. So page.
Miss Wood's evidence.
Yes. So what Ms. Wood says, which again, as I say, is slightly different from the position taken in the pleadings, is 78, paragraph 68. Thank you very much. Is that
Yeah, I've got it. I
in
found
her
it.
view, only the statements of Ms. Marnett and Ms. Tony are relevant. The statement of Ms. Ryman is not relevant. Certainly for the Marnett and Tony statements, the claimant loses solely on the basis.
Well, I'm
of
not sure
correspondence.
that's necessarily right, but we'll get there when we come to discuss relevant.
But certainly the court, because the court is not asked to look at relevance in relation to those statements, then it's not looking at that question in relation to these statements. As I say, that this is what I submit the court is clearly doing at paragraph 97 is applying what I'm describing as a dictionary definition approach to correspondence. She does make reference to other references within the policy to communications between a trust and other related and concerned bodies. And of course, that, insofar as it goes, it's right. There are references in MHPS to instances in which the trust might write letters or write emails or pick up the phone to other bodies about the doctor who is the subject of the investigation. But at risk of stating the obvious, none of them use the word correspondence. They certainly don't use correspondence in any technical sense. And the fact that you may correspond with people about the appellant, in my submission, tells you nothing at all about what is meant by clause 1.6 when it says that you have the right to see correspondence relating to the case. But of course, what one needs to do is to look at paragraph 1.16 in its proper context. And in this regard, I mean the context of MHPS itself. I'll deal with it in the trusts policy because that's the way that the court below dealt with it, but what I'm about to say applies pretty much in its entirety to MHPS itself. The policy starts at 192, the MHPS policy for the trust.
So sorry, where are we going?
192, my lord, just
Yep, I've got it. I've
Ducking
got it.
briefly into
Yes.
the policy itself.
Yes.
Then at 196, this is the policy part, and then there are appendices to it. At 1.1, it describes itself as an agreement between the trust and its local negotiating committee. And it is said to implement the framework set out in maintaining high professional standards in the modern NHS. At 1.2, it says that MHPS must be followed in all cases involving medical staff until the investigation stage has been completed. Then over the page at 197.
Is that in a sense redundant because it actually sets out all the requirements of MHPS anyway?
Sometimes you get cases, I don't think this is one of them, in which the policy fails to implement MHPS properly.
I understand that.
But I don't think that this is case.
In this case, I think it is redundant, but yeah.
But at 197, and this is paragraph 2, it deals with the purpose of the policy. At 2.1, it expresses its purpose as being to deal with cases in accordance with MHPS. And then at 2.3, it says this, and this is something that, if I can put it this way, is Underhill specific. The Trust is committed to ensuring that all conduct, performance and health matters are dealt with in a fair and consistent manner. This policy and procedure provides a framework to ensure that this happens. So there's a contractual commitment on the part of the Trust to deal with matters fairly and consistently for doctors. And then turning forward to page 200 is Appendix A, which deals, which replicates materially Part 1 of MHPS. At 1.3, it deals with the lasting damage that unfounded and malicious allegations can cause, and correspondingly the need to ensure that all allegations, including those made by relatives or concerns raised by colleagues, must be properly investigated to verify the facts so that the allegations can be shown to be true or false, because it is so very serious for a doctor if unfounded and malicious allegations are made.
I see why those negotiations for doctors wanted to put that in. But is it quite apt to the investigation stage? Because the investigation stage isn't the last word, is it? Because, in a sense, isn't all the investigator doing is reaching, as it were, preliminary findings of fact, which, if they are then thought to show matters meriting the conduct or capability process being taken through, will then be tested at effectively at a hearing with live witness, and they're not. You do see in other contexts disciplinary procedures where stage 1 decides the facts,
Yes.
and stage 2 simply takes those facts as given and
Yes.
decides what to do about them. This is not the structure here, is it?
My lord, no. It's right to say that the disciplinary hearing, and what the case investigator does is to decide whether there's a prima facie case, and then there's a disciplinary hearing at which the facts are determined by the panel. I accept that, of course. What, however, the case investigation phase does is two things. One is it sets the case, because it is that report that will then be relied upon by the disciplinary panel. As sort of setting out, if you like, the case that the doctor has to meet. And therefore, if the investigation gets it wrong and fails to get to the bottom of what is a false allegation, then the doctor starts one behind in terms of trying to challenge that case. Of course, there's the point of, well, it shouldn't be for the hearing to correct the failings of the investigation if a proper investigation ought to have come to the view that the allegations were false, is the word that's used. It is
no, but of course that in a sense that's right, but there'd be no point in a two-stage procedure if at the second stage you may get the facts investigated, in quotes, slightly ambiguous term, gone into
yes.
More fully.
Well, as I say, my lord, I accept that at a trust disciplinary hearing, there are likely to be witnesses called, and cross-examined. I mean, whether or not the trust calls all of the witnesses that you'd like to cross-examine is another matter.
Well, let's not just.
But
Isn't that a red herring? I thought, unless there's some very good reason why not, the trust is going to rely on a crucial witness, and their statement is in, and the doctor says, "I'd like to cross-examine them," unless they're ill or away.
yeah, well,
You normally have the right. Are there if that's a contentious issue, we won't.
but
speak about it.
yes, I don't think, my lord, I can make submissions in the context of this case.
Okay, let's
about that.
let's ignore. I don't want to take us too, but I'm just a little bit concerned that this phraseology at 1.3 might, if taken out of context, give a misleading impression of the investigation stage. At least if the word investigated is meant to refer to the investigation stage only.
Yes.
Maybe it's intended to refer to the whole process, which case it would be better if they used a different word.
It may be so. But of course, and I'll come to it in a moment, at the end of the investigation you may be referred to your regulator. So the investigation might be really rather important because it gets your regulator involved as well. It then continues so at page 201, paragraph 1.9, that the first task of the case manager is to identify the nature of the problem and so on. The point being that you shouldn't actually send everything to an investigation, only those cases that warrant it. And at 1.11, that there shouldn't be an automatic attribution of an incident to a particular individual, and a specific reference there to root cause analyses. And I do emphasise that here because some of what's been withheld from the appellant are statements given to a root cause analysis, which MHPS identifies as something that's important because, and I quote, "These frequently show that causes are more broadly based and can be attributed to systems or organisational failures, or demonstrate that they are untoward outcomes which could not have been predicted and are not the result of any individual system's failures." That might be something that a doctor might well want to say something about when giving a view of events in relation to their care of a particular patient.
So logically, a root cause analysis, which is dealt with in paragraph 4.1 of this procedure, or document, or whatever it is, logically that would happen before you start homing in on an individual, mightn't it?
It might well do, my lady. You might well have, and indeed in this case there was a root cause analysis which predated
So it's
the investigation.
In this case, factually, it was a prior stage
Yes.
of the hospital's way of dealing with this
But
particular.
as my lady says, not just factually, but logically, it ought to be the first stage.
Yeah.
Yes. Or, logically, one ought to do a root cause analysis. If one was talking about the care of a patient, one wouldn't do a root cause analysis, for example, if it was a pure conduct concern.
No. And that, of course, spell out the obvious. It's something that's worth bearing in mind when looking at all these procedures. They're not only about clinical decisions, like this case. They are about the whole range of things that may be the subject of a disciplinary investigation, which may be entirely to do with conduct or how you get on with your colleagues and so on.
Yes, of course. And I emphasise 1.11 simply because a root cause analysis was done here, and it is something that is specifically identified by MHPS as important when looking at fault in a broad sense. Then turning forward is at page 202, deals with the investigation itself. And at 1.14, it sets out a number of obligations on the part of the case investigator. And the case investigator, and this is bullet point 4, has to ensure safeguards are in place so that breaches of confidentiality are avoided so far as possible. So that's an obligation on the case investigator. But the penultimate bullet point says, must ensure that a written record is kept of the investigation, the conclusions reached and the course of action agreed by the Director of Human Resources and OD with a medical director. And I do draw attention to that because Mr. Gorton says, well, it's terribly difficult for us to keep tabs of what we have. Well, not if you're doing what you are required to do by MHPS, which is to keep a written record of your investigation. And of course, it wasn't difficult here. Ms. Wood did ultimately produce a list of what she had. And then at page 203, paragraph 1.16 is the basket of rights. The practitioner concerned must be informed in writing by the case manager as soon as it's been decided that an investigation is to be undertaken, the name of the case investigator, and made aware of the specific allegations or concerns that have been raised. The practitioner must be given the opportunity to see any correspondence relating to the case, together with a list of the people that the case investigator will interview. The practitioner must also be afforded the opportunity to put their view of events to the case investigator and given the opportunity to be accompanied.
Can we pause there to ask something which I think maybe you're going to deal with later, but it's a self-contained point. If your construction of the word correspondence is correct,
Yes.
and it effectively means documents, and if the case investigator interviews witnesses and that generates a, whether it's a transcript or a statement, doesn't matter, it presumably follows that that transcript or record of interview will have to be given to the doctor.
My lord, I don't think that I could say that to you, and the reason I don't think I could say that to you is because of the provision that 1.16 makes about interviews. What it says is that you're entitled to a list of the people that the case investigator will interview. So I think I would be constrained to accept that the drafters of MHPS have chosen to make narrower provision in relation to the investigation interviews themselves, and therefore I couldn't say you get the interview transcripts because the drafters have chosen to deal with it rather more narrowly when it comes to the interviews.
Well, it depends. Since you're arguing, you're now having to do.
But you're nonetheless entitled to witness statements generated by the root cause analysis.
Yes, my lady, because that's different. That is not, those are not interviews which would have been provided in the context of the MHPS investigation. They are pre-existing and they relate to the root cause analysis that pre-exists and, as you put to me, my lady, logically will pre-exist an MHPS investigation.
But if the root cause analysis happens before this stage in the process, is information generated by the root cause analysis correspondence relating to the case?
Well, my lady, I say it is, and because what appears to have been assumed by the court below is that correspondence relating to the case must mean written communications, and must mean written communications between people, none of whom can be the case investigator. But if one thinks about it logically, providing documents to the case investigator itself involves corresponding with the case investigator. She is being corresponded with by being provided with documents. There's every prospect, and perhaps in current time certainty, that documents will be emailed to the case investigator. And the judge makes reference to a virtual desk in the course of her judgment. So where does that leave you? Does it mean that the doctor gets the covering email but not the attached documents? Why? Because the documents have been communicated to the case investigator. And then if you say, well, no, Ms. Cricket, you don't get the attachments, what then happens if somebody happens to take your example, my lady? They copy and paste the contents of the RCA into an email. Do you then get it? Because then it's embedded into an email as opposed to being a separate document. You get it if someone happens to do that, but you don't if they don't. And that seems to be, in my submission, deeply illogical and deeply unattractive. So I do say...
Is this an argument that the judge dealt with?
My lady, no.
Was it put to the judge?
In precisely the way, my lady, that I've just expressed it to you, no.
Right.
The way that I put the case to her ladyship below was to say that correspondence that correspondence means documents, but my lady, this is simply an elaboration of that point that I'm making to this court.
Can I put another point to you
Yes, of
about
course.
the interpretation of correspondence in 1.16?
Yes.
You've drawn our attention to 1.14, and there are several bullet points. The drafter of this document has referred to two types of document in 1.14, written statements and a written record of the investigation. So one might think that the draft of the document has in mind that correspondence is a different thing from the two types of document that are expressly referred to in 1.14. One might infer from that correspondence has been deliberately chosen and doesn't include witness statements or the written record of the investigation.
Forgive me, my lady, which bullet point at 1.14 were...
Sorry, it's the 5th and 6th bullet points.
Yes, and I'm grateful. But my lady, I don't think that I would agree with you there, because the reference to written statements there is if one is doing a read across from 1.14 to 1.16. The written statements are the statements that will be generated as a result of the interview. So there'll be an interview, and then there will be a transcription of what somebody has said. That I think is what is referred to when at 1.14 when reference is made to written statements. A written record kept of the investigation, that is documenting what you have done as part of the investigation. I don't think, my lady, for my part, that is making any reference at all to the documents that relate to the investigation itself, as opposed to keeping a record of it.
I think I haven't asked the question very clearly. My point's a slightly different one, which is that the draft of the document, the MHPS, or your local procedure, has referred in 1.14 to two different types of document and
Yes.
used language appropriate to describe two different types of document. How does that sit with your submission that correspondence, which is a different and one might have thought specific word, is wide enough to include other kinds of document?
Well, my lady, and if I can sort of answer the question and then come to it in a little more detail in a moment as well, is MHPS is replete with examples of the drafters using words that you might think have a specific meaning, but actually, on closer examination, they don't. And Kulkarni was an instance of that. And where, on one view, one might say, well, correspondence is used as a term of art and it's supposed to mean written communications. But the minute you start thinking about the implications of that as construction, in my submission, it really falls apart. And one can only sensibly equate correspondence with documents, not least because they are what has been corresponded with the case investigator about, but because also that they are what is going to be required for the doctor to put their view of events in a meaningful way to the case investigator, which is another aspect of their rights under 1.16. Because if you just, and I know that we use this example in our skeleton argument, if the court's interpretation is right, you don't get to see any documents at all unless they happen to be in the form of written communications. So
No, you don't get to see them under this provision.
Yes, but you will never see them. You will never ever see them.
Why not? Why not if they're obliged to show them to you in the interview?
They are, because on because there isn't a record. There's no record. there's nothing in 1.16 which requires documents.
No, that's why I
to
said
be-
under 1.16.
Yeah.
But 1.16 is not necessarily exclusive. The whole thing is suffused by an obligation to be fair. And suppose, to take a crude case, suppose 1.16 didn't exist.
Yes.
And suppose we were taking a case about an operation that had gone wrong. And suppose, rather unusually, the doctor hadn't already got access to the notes. And you turned up at the interview and said, now I want to ask you about what happened at 12:07.
Yes.
And the doctor said, well, I can't answer that without access to the notes. Well, I'm sorry, you can't see the notes. I'm asking you what happened at 12:07. That would be unfair. It would almost certainly be contractually a breach. And it will be no answer to say MHAPH doesn't require us to show you that. You would say, and you'd obviously be right, how can I give my view of the events without giving the material and enable me to do so? But not based on anything about being obliged to show correspondence. It's inherent in the whole process.
Well, my lord, I'd like to agree with you, but I can't. And the reason I can't agree with you is because on the court's interpretation and on the argument that is put against us by the respondent, that is precisely what you can do. Precisely you can say...
Well, I will hear
point-
whether Mr. Gorton said, I don't see any of the judge saying that you could do what I've just put to you.
But, my lord, we did not succeed on the implied term of trust and confidence argument. That's not before this court. You cannot, and the judge does say that, and you cannot use, and the judge does say this, you cannot use the implied term of trust and confidence to get round the express terms of the contract. And therefore, logically enough, if 1.16 makes no provision for the disclosure of documents, there is nothing else in MHPS that says that you get them at interview stage as distinct to in advance.
Well, 1.16 does say that the practitioner must be made aware of the specific allegations or concerns that have been raised. Now, in a case of any complexity about a medical practitioner, that obligation in itself is going to carry with it obligations of disclosure, because you can't just say, well, we say you were negligent at 5 p.m. on such and such a date. You'd have to tell the practitioner an awful lot more.
Well, my lady, what is commonly understood, I can put it that way, as to the obligation to tell somebody what the specific concerns are, is the terms of reference. It's the terms of reference that says we are investigating concerns about how, your dealings with patient A on the 3rd and 4th of December.
We haven't seen the terms.
2017.
Well,
That's the terms of
you
reference
couldn't. Well,
that
they're
we're
very.
looking at.
They're eventually set out in the letter which you showed us.
Yes.
They're in very general terms. That wouldn't be. That you couldn't have a fair interview just by saying I'm not going to give you any documents except that.
But, at risk of stating the obvious, that is what the trust did here, was they provided the terms of reference. Those are the specific allegations or concerns that the doctor is expected to come to interview to answer. But although they gave her some of the documents, they didn't give her all of the documents relating to the case.
Well, that's
to enable her
okay.
to give her a view of events.
Well, there's a risk. I mean, I think it's been
But-
helpful. I think there's a risk of our going round in a circle. We know
Yes.
what your case is on that. But can I put you a related point, which has only really just occurred to me reading this in context? The first paragraph of 116
Yes.
is basically saying what must happen effectively at the start of the investigation.
Yes.
One way of reading, certainly the second sentence, maybe also the third, is to say that this too is something that should occur not necessarily, I suppose, in the very first letter when they're told about the investigation, but as it were at an early stage of the investigation. Practitioner must be given the opportunity to see any correspondence relating to the case, together with a list of the people that the case investigator will interview. So you might have thought, well, all that matters is that the point they're called to the interview, they're told, I've seen X, Y, and Z, and this is what they say, and what do you say about it? But no, you're being entitled to be told in advance everyone they're going to see.
Yes.
Now that's in the very same sentence as the practitioner must be given the opportunity to see any correspondence relating to the case, and together with a list, together with. And what that perhaps suggests to me, I don't say it's leaps from the page, is that we're concerned in a sense with a fairly formal and high level obligation. And it really does mean things like the terms of reference, any letters that have been written to the Defence Society or to the professional regulator, rather than documents generated by the investigation, or indeed documents from the past which are going to be brought into the investigation. You follow me?
I see the point that you're putting to me, my lord. And as you say, it doesn't jump out from the page. It may be that you get the documents at the same time that you get the list. Maybe it doesn't. I don't think that 1.16 says that those two must be cleaved together, and if they're not,
no, but
then
it
you're
is
in breach
odd.
of
It's the
1.16.
together with a list of the people that he will interview. That's really what made me, reading it
Yes.
again, made me think that we're, well, I don't know.
Well,
It needs careful thinking about, but I put the point to you.
Yes, it appears, I can put it that way, it does appear that you get the documents before the interview, because if you look at the natural sequencing of 1.16...
Oh, well, you certainly, yes, you get the correspondence before
Yes.
the interview. Yes,
exactly.
certainly. You get that at the beginning.
And there must be a point to that. There must be a purpose. And the purpose must be, I'd suggest, so that you can put your view of events to the case investigator. And getting a letter that's been sent to your defence organisation may do very little
Well,
to help you
that
in
comes back to the
process.
question whether this is the sole source of the obligation of disclosure.
There has never been any suggestion by anybody, and in particular the respondent, that there is somewhere else where you get rights of disclosure. In
There's
fact,
one from me now.
yes, well, my lord, yes, but what has always been the respondent's case is that you don't get anything at all until you are pitched into the disciplinary hearing phase, at which point they get to give to you the documents that they're going to rely on. It's never been suggested that there is any other source of obligation other than
Well,
1.16.
we will.
And
Mr. Gorton can prepare himself to be asked questions about that. But
yes,
Just as a follow-up to my lord's,
of course, my lord.
can I just suggest what another approach which probably gets to the same destination is that on its true interpretation, it might be said that the final sentence potentially includes such an obligation. The practitioner must also be afforded the opportunity to put their view of events. And my lord gave the sort of obvious example. At the interview, the practitioner is asked about 1:03 a.m. on such and such a date.
Yes.
And says, well, I can't put my view of that unless I can see the notes relating to that time and that date.
and indeed, if I may interrupt, have been sent them beforehand so that I can study them.
Yes,
Yeah,
quite.
exactly.
So
Otherwise it's a waste of time.
all I'm putting to you may or may not agree with this, it is that implicit in that final sentence, and nothing to do with the word correspondence, is that there may be, depending on the facts, there may be documents which do have to be given to the practitioner in order to make that last sentence work effectively, and if one needs to say this, work fairly. But it doesn't follow that anything and everything which is a document relating to the case must be disclosed. Because you have fastened your argument before the High Court, as I understand it, on the word correspondence relating to the case.
Yes.
And if the High Court is right, that the documents you seek do not fall within the meaning of that, well, you lose this ground then. That wouldn't mean
Yes.
that the procedure can be unfair. That's a different point.
Well, my lord, I take the point that you put to me, as you rightly say, that's not how it was approached below. The argument, the battlegrounds were very much around what is correspondence relating to the case. But perhaps if I can put it in this way, maybe in one sense it matters not if one is looking at that sentence or the next sentence. What does, however, matter is that in order to have the opportunity to put your view of events, you must still be able to have the documents, all the documents we say, relating to the case. Because
only if it truly is necessary for you.
Well,
because one view would be, well, you know what happened. Tell us what you say happened that night.
My lord, I think that the use of the word necessary is perhaps a little bit of a slippery concept in this particular context, because of course there is narrowly what happened that night. To take that example, you know, who did what, when, and how. But there might be other issues that you'd want to provide your view of events on. You might want to say something about the fairness of the process. You might want to say something about mitigating factors. And you might well want to see documents
Not
that
in the
relate
investigation
to all of those
stage.
things. Well, my lord, yes, because it's all going to go to what you say about whether or not there is a case to answer, and a case to answer that has to go to a disciplinary hearing, because there's a multitude of options that's open to the case manager at the end of the investigation, and that's provided for by paragraph 1.20, that you can do a number of things, one of which is to send the case to a hearing, one of which is to send the whole case for further exploration by NCAS. You might say it needs to go to occupational health. You might say there's no further action. But it's not binary. It's not the sense of either the case is not well-founded, in which case nothing happens, or it's a case that's well-founded and therefore inexorably it goes to a disciplinary hearing. And therefore the doctor must, in my submission, have an opportunity to ventilate everything in terms of providing a view of events.
She can. No one's stopping her saying all of those things, if that's what she wants to say at the interview. The only question is whether she's entitled, before the interview, to see all the documents. Now, you rightly or wrongly, have fastened on the word correspondence, and you say that's the origin of the obligation. If you're right about that, you win.
Yes.
On ground one. If you're wrong about that, you lose. All I'm saying is that just because you lose on ground one doesn't mean that they can conduct the investigation unfairly.
Well, my lord, I don't want to repeat myself, but there is nowhere else in this, other than clause 1.16, which says anything about disclosure in relation to the investigation phase, and no one has suggested otherwise.
Well, we've explored this extremely helpfully, been much helped by your submissions. But that's probably all we can say about the close analysis of 1.16, and I know you've got a lot of ground to cover, though I suspect a lot has been anticipated.
We do, therefore I'll try and make a number of points fairly swiftly. I've made reference to the Skelton argument, in which we say on the court's approach, you get the letter to the GP, you don't get your clinic notes. What Mr. Gorton says is that the suggestion that a practitioner would be refused access to relevant documents in clinical cases is fanciful. To which I say, well, it isn't, because here the appellant has been deprived of RCA statements, and of course whether a trust might or might not take that approach can't determine the question of interpretation. But I do say that that is an implicit acceptance by the respondent that the court's analysis is problematic, because it is inconsistent with the purpose of MHPS, which is that you should be making a decision about a case to answer only once you've had a right of interview.
Ask a question about the RCA statements, the two that are said to be relevant.
Yes.
Take Miss Marnett. One can easily see why that's likely to be relevant, because she was the surgeon conducting the operation and at the other end of the phone. But in order to conduct a fair investigation, would it not be enough to say well, we have seen from the evidence she gave to the RCA analysis that Ms. Marnett says that she did ask you X,
Yes.
and you say, no, she didn't, or she did tell you this bit of clinically crucial information, and you say she didn't. And that would still give you the opportunity to say, yes, but you just say, I deny it, or you could say,
Yes.
well, but Ms. Marnett I remember the conversation, but Ms. Marnett was confused, and so on. I've no idea, obviously, what it would be, but the point is you don't need to show the statement. What you might need to do, if it was crucial, that obviously the investigator has to decide what's crucial, you might have to give the doctor the opportunity to comment on the gist of what is in the statement.
But, my lord, to take that example, it might be being deliberately hypothetical. You're asked a question about what Ms. Marnett says at paragraph 5 of the statement, but you don't see anything else. At paragraph 10, Ms. Marnett might say something completely different, but goodness me, you'd like to comment on that. She says something about something else that happened that evening, which you say sheds light on the credibility of her account at paragraph 5. You might say she says something that is relevant to mitigating circumstances about what happened that evening. You might say that she says something at paragraph 10 that makes you go, hang on a minute, how did this come about? That doesn't seem to be fair. There's a whole host of things that you may well not appreciate unless you yourself have had an opportunity to read that statement top to bottom, and not just comment.
Which you will almost certainly get at the disciplinary hearing stage. You can't make the investigation a complete dry run for the disciplinary hearing, if there is one.
Well, my lord, I have accepted that you don't get the interview statements. So, of course, in that sense, the investigation phase is not a dry run for the whole of the disciplinary hearing. But what on the respondent's analysis is the case is that if the trust decides that it doesn't want to rely on the Marnett statement, you've never had it, and therefore the disciplinary hearing is not going to make good the problem or the deficiency that you've suffered at the investigation phase, because you don't have it and you'll never have it. And that was certainly common ground below.
This is the what in criminal procedure would be called unused material.
My lord, absolutely
Yes.
so. Because if you were in a criminal context, if you're in a regulatory context, there would be, I would accept, of course, you would be told of the case against you at the investigation phase. But if you were going to be charged, whether in a criminal or regulatory context, you'd then get unused material.
Sorry, I don't want to...
Forgive me, my lord.
No. I think it's only fair that you should know, and that Mr. Gordon should know, that speaking for myself, I'm becoming increasingly anxious about what this appeal is actually all about. The parties appear to have treated various things as being, because they were common ground, and perhaps rightly, have treated various things as being true, where in fact they're not directly an issue before this court at all. So, for example, the question of whether someone is entitled to the equivalent of unused material if they're facing a disciplinary hearing. Well, on the facts, that's not an issue in dispute in this case, because we haven't reached that stage, and we may never reach that stage. So, and you were right to point to the judge's reasoning, which you showed us earlier this morning, where she seemed to work back from that apparent common ground.
Yes.
I think it's 101, paragraph C.
Yes.
But all I'm doing is laying down a marker that the council should not necessarily assume, that I at least, accept the premise.
Yeah. I'm grateful, my lord.
But it doesn't follow that you win on ground one, because ground one concerns the meaning of the word correspondence.
My lord, I accept that. But you are right to say in a criminal or indeed a regulatory context, you would get unused material. But there is nothing in MHPS which provides for an unused material phase. There is 1.16, and then there is what you get at the capability hearing phase, and there is nothing at all in between in terms of a right of disclosure. And of course, one might say this as well, is that unused material is is good insofar as it goes, but of course you get the unused material after the point at which you've been charged. And what we do know under 1.16 is that you have an opportunity to put your view of events, and I'm seeking to persuade this court in any event that the opportunity to put your view of events meaningfully must comprise also of an opportunity to comment on the documents which relate to the events that you're being asked about in a broad sense, not just literally who did what to whom and when and how, but also other matters which might bear on issues such as mitigation and the fairness of the process. I have the court does have in the appellant's supplementary bundle some training documents on the national training of case investigators and case managers. This was adduced by the trust below as supporting its interpretation of clause 1.16.
Can we look at it?
We can look at it very briefly,
Yes, well,
my
I
lord.
have it here.
It is in the appellant's unagreed bundle, and there are only a handful of pages that I need to take you to. First of all, page 45, please. So these are the slides which deal with the training provided by an external NHS organisation called NHS Resolution to case investigators. And it's the top slide, which is the obligation to index the evidence, which is the answer to the "it's all very difficult" point that Mr. Gorton raises. I don't mean that in a pejorative sense, just by way of shorthand in terms of what he says there. There are some fairly stringent obligations in terms of documents keeping. Then at page 47, it deals with, and it's the top slide again, evidence/comments from the doctor, that the doctor should know what documentary evidence is being reviewed, and the doctor should be encouraged to submit relevant additional evidence and comments in line with the terms of reference. And then at page 50, it deals with, and it's the bottom slide, inviting witnesses to interviews. The doctor should be written to explaining the investigation process, what's being investigated and confidentiality, the invitation to interview, the right to be accompanied, and then finally, copy of terms of reference, list of witnesses, and disclosure file. So
yes. What is the? This is quoted by the judge, I think. What, or I've seen it referred to somewhere. What is the disclosure file? Is that a defined term in these slides?
it's not a defined term in these slides. As I say, it was put forward.
Sorry, I didn't hear. It's not.
It's not a defined term in these slides. I put it before the court because I say that the reference, if on the respondent's approach, you don't have to give a doctor anything at all, but that is certainly not what NHS resolution seems to think. It seems to think that you get a disclosure file, and a disclosure file appears to suggest that you get correspondence.
Sorry, how is this slide relevant to the correct contractual interpretation?
My lord, I can take it no further than saying that that is how a national NHS organisation which trains case investigators and case managers has taken the view of what a case investigator is required to do. I put it no higher than that.
Well, it may be against you, which I presume is why the trust put it in, on the basis that you will get some material. Doesn't spell out what principles the disclosure file is produced, but it will be consistent with what my lord and I have been putting to you, that you'll get some anyway in order to have an effective interview.
Well, it would appear to, if one maps this onto 1.16, terms of reference appear to be, the specific allegations. The list of witnesses, well, we know that that's provided for by 1.16. Disclosure file would appear to mean correspondence relating to the case.
Yes,
so it is, as I say, NHS resolution seems
But no explicit link is drawn between these training slides and the express terms of NHS.
No, my lady, and that's why, as I said in
And it
answer
doesn't
to
purport to be a document interpreting.
my lady, I accept that too.
Yeah,
All I say is that if it is said, well, it's so.
But it's consistent with, as my Lord Justice Underhill has just suggested, it's consistent with the view that there may be another sort of obligations to give material to a practitioner.
Well, my lady, I think I've probably said what I can about the,
You know,
the slides.
that's very helpful. Just so that we know, I really don't want to get bogged down in this, but there's actually two what look like rather similar types of things. What you've been showing us, I think, was from document 3 by the index,
Yes.
which actually says NCAS case investigation course. It actually appears to be NHS resolution.
Yes.
And then 4 says NHS case manager training.
Yes.
I see one's for the case manager, one's for the case
Yeah,
investigator.
exactly. So the materials I've just taken you to are from the case
Yes, I see.
investigator training.
Okay, thank you.
And then, so just bear with me 1 minute. The question of what is meant by 1.16 has been looked at, albeit in very brief terms, except that by the High Court in the case of Hussain and Surrey and Sussex. You have that in your authorities bundle, and it's in particular page 63 that I wanted to look at, if I may, please. So it is paragraph 136 at page 63. And part of Dr. Hussain's complaint was that she, I think, had been deprived of an opportunity to see correspondence relating to the case, in particular NCAS correspondence. The judge, Mr. Justice Andrew Smith, says, I would not interpret paragraph 1.15, which for us is 1.16, as covering correspondence from NCAS to the Trust, giving guidance about how to deal with the concerns that were the subject of the investigations. I consider the paragraph is directed to correspondence about and evidencing the matters that are the subject of an investigation. There is no evidence that Dr. Hussain did not have the opportunity to see such correspondence. So the High Court appears to treat the obligation to provide correspondence related to the case as not meaning procedural correspondence, which is how the respondent puts it, but actually correspondence evidencing the matters that are the subject of an investigation. And that, in my submission, can only sensibly be read as meaning documents, because it's documents that evidence the investigation that has been carried out into the practitioner. So I'll then just deal with the rationale of the court. We've looked in part at what Mrs. Justice Thornton says at paragraph 101. That is to be found in the core bundle at page 87. But we've looked at C and we've not looked at any of the others so far. At A, she says that disciplinary matters are in their infancy, and the case it may be that the case progresses no further past the investigation interview. To which I would say, well, precisely so, and that is why the opportunity to comment on documents is so important. At B, she says that the MHPS does not make any reference to a pre-interview disclosure exercise. Well, that rather begs the question that she had to determine in the case, which is what did 1.16 mean. We've explored 101C, in which the judge appears to try and work backwards from part 4, but I think I've probably said plenty on the fact that that simply doesn't work. Then at D, she says that it'd be surprising if this is a feature of MHPS, but not of the preceding, more adversarial HC99 regime. Now, I know that my lady has asked to be shown the HC99 materials, and we will endeavour to do that, of course. But it doesn't really, in my submission, provide an answer to this point, because it used to be that you get all the evidence and you had the right to challenge it in an adversarial process. The court's interpretation replaces that with nothing bar limited written communications, which may shed some but not complete light on what it is that you're being asked about. And then at E, she makes reference to the ACAS Code of Practice on Disciplinary and Grievance Procedure, and also to the ACPO guidance on criminal interviews. The court, I think, has my point. It's not a question of statutory fairness. It's a question of the interpretation of this collective agreement and therefore this contract. And then to turn to the points taken by the respondent, with respect, they add little to that analysis. For the court's note, it's paragraph 42 of Mr. Gorton's skeleton argument. It's suggested that the first point that's made is, well, it's near impossible to remember all the documents. Well, why? Clearly, Ms. Ward could, and you have an obligation to index documents in any event.
Sorry to just stop you here. I'm concerned about time, and
yes.
We won't cut you off directly at one. The party opening always is entitled to a bit longer because you're introducing us to material and so forth. But you've only got a very limited time after lunch.
Yes.
I wonder whether just making bullet point answers to Mr. Gorton's skeleton is the right way to deal with it. You'll have not much time for reply, perhaps, but enough
Yes.
time for reply to deal with the points that really matter.
My lord,
Because you're still on round one, aren't you?
I am, and I'm grateful for that indication from the court. I will, with that in mind, perhaps deal with that, if I may, by way of reply, but there are some points that I'd want to make by way of reply. My lord, I'm mindful of the time, but I think there is probably time for me to make just a start on ground two, if that's helpful to the court. It's suggested that if the appellant doesn't succeed on ground one, then ground two is academic. Well, that plainly is wrong, because the appellant got home on correspondence in terms of the correspondence with the parents, but fell down on the question of relevance. The court equated related to with relevance, and in due course accepted, we say uncritically, the case investigator's assertion that the written communications with the family were not relevant to the case. And whether relevance is a question of discretion, and the treatment of discretion of grounds 3 and 4. Ground 2 is therefore concerned with whether the equation of relating to with relevance was correct or not. And we submit obviously not. It is neither what relating to means on a literal approach, and it does nothing to advance the purpose of MHPS. And one might say, well, why does the court say that it means relevant rather than relating to? This is dealt with comparatively shortly in the judgment of Mrs. Justice Thornton. It's paragraph 100 and page 86. She says that prima facie it's a decision for the case investigator. She points to the wide measure of discretion provided for in 1.18. With respect, that's not the point. 1.18 is a general discretion, but 1.16 provides for distinct rights that are afforded to the practitioner. It then is said that the claimant's case that relevance is a matter of law for the court draws the court into micromanagement. Well, again, with respect, that is not right either. Micromanagement is a concept that will be very well known to this court, whereby minor irregularities or minor breaches are said to be a reason not to be given, for the court not to intervene by way of injunctive relief. It doesn't tell you anything about how you analyse a clause in the first place. There's no authority that says micromanagement is a relevant tool of construction of the contract. And therefore, effectively, one is left with, in my submission, no good reason as to why it is said that relevance is relevant means relating to. I should also fairly refer to paragraph 99, where she also talks about correspondence relating to the case, and then says the claimant's interpretation of the phrase refers to any document seen by the case investigator, could extend to anything that has come across the case investigator's virtual desk without any qualification of relevance, whether the documents remain in the case investigator's possession. As to which, well, it's the same indexing point. The case investigator knows what she's got. It then says that the claimant's interpretation sits oddly with the accompanying reference in paragraph 1.16 to the provision of a list of people to be interviewed. Genuinely, I do not understand how it is said that a reference to a list of people tells you anything about what relating to means, because a relating to tells you what the scope of inquiry is, not the level of detail of the material that you get. And it is then said that the claimant's interpretation could lead to, quote, an unworkable amount of information to be disclosed, which could in turn raise confidentiality and data protection issues when the document in question may not even be relevant. But to unpick that briefly, unworkable, why? These are documents which have already been identified and passed to the case investigator. If it's not unworkable to provide them to the case investigator, why does it become unworkable at the point at which you provide them to the doctor? And in this case, of course, we know that we're talking about 3 or 6 documents. The judge does not identify the confidentiality issues that she's referring to at paragraph 99. But the court already has my submission that confidentiality may require redactions to a document. It is not a reason not to provide the document at all. And then data protection, which, as I described, is the perennial red herring in this case, because, and the court has the material provisions from the GDPR in its authorities bundle, but I know that the court will be very familiar with this, is that lawful processing of data can be on the basis of data subject consent, but also can be because it's necessary for compliance with a legal obligation to which the controller is subject. And a legal obligation here includes the provisions of MHPS, which is a contractual document to which the trust has to give effect by virtue of its policy, which is incorporated into the contract. My Lord, I then just wanted to say something about the respondent's case very briefly, if I may. The respondent says that relating to means arising from. It does not, but in any event, arising from doesn't mean relevant either. And I do say that relevance is an inherently problematic concept at an investigation phase, because an investigation is an iterative process where you're looking at the evidence, you're identifying documents which bear on the issues to be investigated and reaching preliminary findings of fact. It may genuinely not be obvious to you at the outset what is relevant as a case investigator. The court then has the submissions I've already made on the fact that there may be aspects of relevance that the case investigator herself has not identified. Documents can bear on broader issues than simply what's happened. They can relate to, for example, the fairness of the decision to commission the investigation, which was an issue here, or mitigation of culpability. And I know that the court will have the provisions of MHP, of the policy well in mind, and in particular clause 1.18, which requires the case investigator to identify exculpatory evidence as much as inculpatory evidence. So a doctor might not just want to comment on the documents as they stand, but say, well, hang on a minute, that also sets me on a train of inquiry about some other things that I think you ought to look at as part of this process. And it's said by the respondent in a number of places that our approach is generating litigation. Well, arguments about whether the case investigator is right or wrong in an assessment of relevance is precisely the sort of thing that is likely to generate dispute and likely to generate litigation. And the respondent implicitly accepts that too, but they seek to make their solution in the notice that clause 1.16 is subject to an overriding discretion on the part of the case investigator to withhold documents even if they are relevant. And in my submission, the straightforward approach, whether it's literal or indeed purposive at this juncture, is to regard relating to as meaning precisely that. The documents relate to the investigation if they've been seen by the case investigator, and they should therefore be provided to the doctor.
I hadn't read the judge's judgment as saying that, and you may be right, but paragraph 100, the judge says the test of relevance must, it seems to me, be prima facie a decision for the case investigator and not the court.
Yes, and forgive me, my lord, I think it's my fault because I took you to 100 rather than 99 first, because at 99 she deals with the argument about does relating to mean relevance,
yes,
and then goes on at 100 to say, having decided that it is relevant, then says relevance is a matter for the case investigator and not the court.
Prima facie.
And forgive me, my lord.
Prima facie is for the case investigator.
Yes.
Doesn't mean it's unreviewable by the court, just that it's a matter of judgment for the case investigator in the first instance.
Yes. My lord, that is what I was going to turn to after the short adjournment,
yes,
in relation to grounds 3 and 4.
So you've, that's it on ground 2.
My lord, yes.
How much longer do you think you're going to need on grounds 3 and 4?
I have 3, 4 and the respondent's notice. I would hope with a fair wind I can get that done in 45 minutes.
25?
45.
It's too long. It doesn't leave any time to Mr. Groughton. Half an hour, and that's a maximum, not a target. So
My
you
lord,
have to
I-
cut your coat according to your cloth.
Of course.
Mr. Groughton, I don't think you will be unfairly affected by that because your submissions are essentially responsive, but you too will have to cut your coat according to your cloth because we must give Ms. Criddle a reasonable, though not generous, time for reply.
My lord, yes.
Right. 2 o'clock.